Honor.
Same questions for the defense?
Thank you, Your Honor. We've received the pre-sentence investigation. I've gone over it with my client. We have no objections or corrections to the pre-sentence investigation document, and there are no pending motions on behalf of the defense.
All right, thank you. Does the state have a recommendation to make at this time?
Yes, Your Honor. In FECR 133583, on count 1, the charge of robbery in the first degree, the state recommends that the defendant be sentenced to an indeterminate term not to exceed 25 years in the custody of the Iowa Department of Corrections. In count 3, the charge of attempted murder, the state recommends that the defendant be sentenced to an indeterminate term not to exceed 25 years in the custody of the Department of Corrections, and the state requests that this court enter those sentences and order them to be run consecutively to each other. Count 2, the theft in the first degree, we believe merges with count 1 and should be run concurrently with the other 2 offenses. The reason for this sentence, Your Honor, is the brutal and violent and predatory nature of these offenses. On April 25th, 2022, almost 4 years ago, the defendant watched Ann Rizzo walking home from work as she had been doing for decades. He waited for her to be alone in a dark place, and he brutally attacked her, strangling her until she was almost dead. The only reason she isn't dead and that she's in the courtroom here today is because 2 students, Catherine and Madeline, were walking out from studying and caught him in the act. And Anne is here today because of those 2 students and because the defendant got up and ran away. We believe this consecutive sentence is necessary to protect the community from further offenses by this defendant. We further request that in FECR 138065, the charge of escape, that sentence, the indeterminate term not to exceed 5 years, be run consecutively to the charges in FECR 133583. The state would also request a no contact order be extended in this matter and that the defendant be ordered to pay any restitution. Thank you.
All right, thank you. Mr. Powell?
Thank you, Your Honor. I would address the court regarding FECR 138065 first. In that case, Your Honor, my client has entered a guilty plea to the charge of escape, and we have no objection to the 5-year sentence in that matter running consecutive to his sentence in case number FECR 133583. Point of clarification, I think the order from December 5th on page 6 indicates that the court found my client guilty of theft in the 2nd degree, but I think consistent with the rest of the document that was meant to be theft in the 1st. And I agree with the state that the charge of theft merges with count 1 regardless, and so I don't think it makes too much difference. Your Honor, really what this comes down to, obviously the court has found my client guilty of a dangerous and terrible act that occurred several years ago, but we are asking that the court sentence him to 25 years on count 1, 25 years on count 2, count 3, merge the charge in count 2, but to sentence and run the 2 25-year sentences concurrent with one another, but consecutive to the charge of escape in the other case number. The reasons for this are as follows. My client, Your Honor, was 18 years old at the time of the commission of offense. He had virtually no criminal history whatsoever at that time. He was a college freshman, and although the acts of that day were certainly dangerous and disturbing, he had no criminal history up to that point. Also, I would make the argument that although the events of that day and this offense could be characterized as 3 separate crimes, it was essentially one singular event. In other words, the act of assaulting Ms. Rizzo, the act of putting his hands on Ms. Rizzo's neck and stealing her earrings essentially was one activity. It was one incident. And although that does not make him not guilty of the offenses, it is relevant for the court to determine whether or not There are separate and distinct crimes committed here that would merit or even allow consecutive sentences. Given that it was disturbing, yet essentially one series and one action, we believe that concurrent sentences are appropriate, both legally and just out of a sense of what the court ought to do in this case. 25 years with a mandatory 17 and a half years on that, Your Honor, will mean that my client will have to serve at least 17 and a half years. When you add the escape charge to it, it certainly may be more than that. By the time he would have the possibility of parole, he would be in his late 30s at best, and we believe that that will provide for the protection of the community for a good long period of time where he will be incarcerated, but still give him the possibility of rehabilitation should the Board of Parole decide that nearly 20 years from now, for example, he is potentially someone who could be let out on parole. We are asking that the court allow that possibility and sentence my client to essentially 30 years running counts 1 and 3 concurrent with one another. Thank you.
All right, thank you. And then does your client wish to exercise his right to allocution today?
No, I wasn't planning on doing it.
Okay.
No, thank you, Your Honor.
All right, that's fine. All right, well, I have to say that the decision to run these cases consecutive or concurrent is a very difficult one, and I had to assess a number of different things. First of all, I agree with both attorneys that count 1, that count 2, which is the theft in the first degree, would merge into count 1. Which was robbery in the first degree. So I did consider quite a lot of information. I read the PSI and, of course, all of the information in the file and what was presented to me. The final analysis, though, I'm not going to keep everyone in suspense. I am going to run counts 1 and 3 consecutive to each other. I'm going to run FECR 138065, which is the escape, concurrent with the what's going to amount to a 50-year sentence, because I do think that there were 2 separate acts that really do merit running these things consecutive to each other, and the final analysis of everything. And I'm not going to go through all of the findings of fact. I put those in writing, but I do think that there were 2 different things that happened here. There was the attempted murder, and then there was the robbery, which involved the theft of the item in question, the jewelry. So I guess just in listing out all the things I'm supposed to consider, of course, and is that the nature of the offense, which I thought really cut against the running these things concurrent with each other. I would admit the defendant has almost no prior criminal history, but the obligation to protect the community, I think, weighed very heavily in my decision to run these things consecutive to each other. And so that's my decision, that's what I'm going to do. And I do agree with a lot of the reasons enumerated by both counsel in this, but I think when I consider the act itself, there were 2 separate acts, both should be punished separately, and so that's what I'm going to do. Anything else on behalf of the defense at this time?
Not at this time, Your Honor.
Anything else on behalf of the state?
No, Your Honor.
Okay. I don't believe that there are any fines on these Class 3 felonies. The fine, if there is one, on the 5 years of the suspended And you do have a right to appeal my sentence to the Iowa Supreme Court. If you choose to file an appeal, you must do so within 30 days of today's date. There won't be any bond afforded to you on appeals. These are forcible felonies. Anything else on behalf of the defense?
No, Your Honor.
Anything else on behalf of the state?
No, Your Honor.
Then we're adjourned. Thank you.